Well, hello, everyone, and welcome to yet another episode of HR Office Hours. I'm Sandy Zannino here with my friend Brad deBeaubien.
Hey, Sandy, good to see you.
It's good to see you too, Brad. So we've got today to talk about, but this is breaking news, right?
Breaking news.
Breaking news. The NLRB has issued, is it a rule? So let's talk about it. The NLRB, and it's a bit of a surprise, apparently. Why don't you tell us what is happening?
Sure. So I guess to rewind the tape a little bit, we've been waiting on the Federal Trade Commission. And Sandy, we've had a couple now, talking about the status of non-competes, and that the FTC has made clear that they're gonna likely propose or issue proposed rulemaking that would ban non-competes pretty broadly nationwide, which for a state like ours, Florida, which is pretty friendly to the use of non-competes, would be a major, source of friction. There's a whole bunch of questions, but that rule hasn't been pushed out yet. They've said they're going to push it out. We think now it's probably going to be sometime in 2024. So everybody's kind of in a holding pattern in terms of what they're doing with respect to non-competes and the FTC.
We were all waiting for the comment period to be over.
Yeah, that ended, right? So that cut off, I think, in April. They extended it a couple of times. I think it ran into April or maybe even early May. And now they're sort of processing the many tens of thousands of comments that came in. And we don't know what the ultimate proposed rule from the FTC is going to look like. Recall also a couple of, maybe it was a month or two ago, the National Labor Relations Board, that's a federal agency that's tasked with enforcing the National Labor Relations Act, which protects union activity for unionized workers, but also employee rights under the NLRA generally, and some of those extend to workers that are not necessarily in unions. All employees have some rights under the NLRA to engage in what's called concerted protected activity. So anyway, they issued an opinion a month or 6 weeks ago limiting employers' ability to use non-disparagement and confidentiality provisions in employment agreements, severance agreements. Yeah. And we talked about those, and we talked about how they sort of got there. That kind of came out of left field, but it was like, oh, okay, well, this is an odd, this is an interesting development.
So Brad, can we pause just a minute for any listeners who may be a little confused about how the NLRB applies to them if they are a private employer? You mentioned the protected concerted activity.
Right.
To me, that means an employee's ability to talk about their working conditions, even their boss with other employees, right? Like water cooler.
That's really it. Yeah. I mean, it's, and again, I think we've said a couple of times we need to do just a whole specific episode on this. I don't think we've done it yet, just about, those most employers, I think, are not aware of the rights that their employees have under the National Labor Relations Act, NLRA, which is again regulated by or overseen by the NLRB, the National Labor Relations Board, which is exactly what you said, Sandy. It protects all employees' right, even if they're not in a union, all employees' rights to talk about the terms and conditions of their employment, right? So certainly it protects their right to talk about unsafe conditions and truly egregious, horrible treatment. Right, you think about the origins of unionization and sweatshops and all that stuff, right? That's the sort of what it was derivative of. But anymore, it really protects any right. So if two employees want to talk about their compensation and how one's making more than the other, even though they're doing the same job, right, it protects those rights as well. And so a common misunderstanding of employers is, oh, I can make my employees not talk about compensation, and you really can't, because they have that right to talk about. That's a term and condition, a fundamental term and condition of their employment. So it's a good point. The NLRA extends to virtually all employees. Now, supervisors are carved out from that somewhat, right? Because they're supposed to have the company's best interest at heart. So that not all supervisors enjoy the full protections of the NLRA.
Okay, so that's an important caveat.
And that is an important distinction. And we talked about that a little bit in our McComb-McLaren decision, which is about the confidentiality and non-disparagement decision from the NLRB a few weeks ago. Anyway, where are we today? As of yesterday,
here's the news, y'all. Here's the news.
The big news. The general counsel of the NLRB, Jennifer Abruzzo, issued a 6-page memorandum, which essentially said that, it's her position that most non-competes are violative of employee rights under the NLRA. And what that means exactly is not clear, and will become clearer over time. And it's not clear for a couple reasons, and I'll unpack for you what she said and then why it's not clear. I guess let me start with that though. She's just issued a memo as the general counsel, right? So that doesn't have the force of law. That was her directive to subordinates within the National Labor Relations Board, that they should be on the lookout for cases where they can, in response to charges that are filed, bring claims, trying to enforce the rights of the act on behalf of employees against violative non-competes. And so this was her directive to let's go pursue these cases. What we would ultimately need to have some law on this is a decision by the NLRB saying, yes, non-competes are in violation of the act. She's just sort of teed the issue up. But what I think that does is it opens the door potentially, for any employee who finds themselves on the receiving end of a non-compete enforcement action to say, well, I'll see your non-compete case and raise you a charge filed with the NLRB that you're violating my NLRA rights, my Section 7 rights, which is the section of the act which protects that right. And GC Abruzzo outlines in her memo, 6 or 8 different bases and reasons why she thinks that non-competes are in violation in most instances of those rights of employees to engage in protected concerted activity. The gist of her arguments, and we could debate the merits, I don't think it's particularly well reasoned, but the gist is, look, if employees know or believe that they have these non-competes, then it chills their ability to leave an employer en masse, to realign themselves at a new employer if they don't have the ability to go to that new employer because they have this non-compete. There's a bunch of arguments sort of along those lines that the notion that, well, I can't leave this employer because I have a non-compete, and so it really limits my options. Therefore, I can't speak my mind with my current employer because I don't have a place to jump to if that conversation doesn't go well. And I sort of get it, but I think that there's some problems with the argument. But that's the path they're going. I mean, she's the NLRB general counsel. She's got to play the cards she's got. And those are her cards, right? They're the NLRA rights.
There's one in here that she talks about that it chills employees from soliciting their coworkers to go work for a local competitor. I mean, that's, I don't know.
Yeah, but I mean, and that's a non-solicit, right? That's sort of different than a non-compete. Although I guess if the former coworker has the non-compete, you'd argue, well, that that too chills it. But the solicitation piece starts to get into a whole other set of issues.
Yeah, but she put it in there.
Yeah.
I mean, she put it right in there, and it says they do so because employees cannot act on the solicitation without breaching the agreements.
Yep. Another troubling aspect of this, if you're an employer, is, well, what are the remedies? What's likely to come of this? And I mentioned, right, I think one potential upshot could be if you sue an employee or a former employee to enforce a non-compete because they've gone to a competitor, they may, in addition to defending that lawsuit, file a charge with the NLRB and say, well, look, this agreement was in violation of my Section 7 NLRA rights, right? And now you got to deal with that. And again, just because somebody's gonna, got some ammo to shoot back at you doesn't mean you don't go after them if you feel strongly and you need to do that. But it just does create a whole nother set of issues that employers may have to deal with if they're pursuing enforcement of non-competes. Go ahead. I was gonna make one other point though.
It's a whole other set of legal fees, isn't it? I mean,
yeah, absolutely. Yeah. You've got a whole different forum, right? This is a charge of discrimination that will be filed with the National Labor Relations Board that you would then have to deal with, just like a Title VII type charge filed with the EEOC or your local state, right, human rights law authority, right? In addition to having your non-compete lawsuit filed in state or federal court, you'd now be defending a charge filed with the NLRB. It's sort of it's a dual track, two-front war at that point.
Right.
The second thing I wanted to mention, though, in terms of risk for employers, at least what we can immediately perceive based on this memo, is what she says in the concluding paragraph of her memo is, regional directors should seek make whole relief for employees who can demonstrate that they lost opportunities for other employment, even absent conduct by the employer to enforce the provision. So what that means is if, hey, you have foregone the opportunity to make a move just because you knew you had this thing, even if the employer never said boo about we're going to enforce it or shame on you, you shouldn't be doing that. If you know you have it and you can demonstrate, well, I had a great offer, but I didn't pursue it or I couldn't take it because I had this non-compete. The GC of the NLRB is saying, well, that's you need to make that person whole. What that looks like. Obviously, there's a monetary damage, right? If they're going to make more money, then maybe you need to help them in that respect. But it just sort of leaves open this whole door of, certainly trying to enforce a non-compete that the NLRB deems, if they do ultimately deem those, improper, is problematic. But now they're saying if you just have one out there and somebody has perceived that as limiting their options, now they may have a claim too, and you could potentially be on the hook for make whole relief, whatever that may mean. Like I said, it's just a new, it's a really interesting development, and it raises in the short term more questions than it answers. But we just see more of the non-compete landscape kind of shifting, shifting sands kind of place.
So Brad, for the risk averse employer, right? Like for those employers who don't even want to go there, would it be at this time, would it be prudent maybe to limit the non-competes to, C-suite, maybe, higher level employees, shareholders,
there are some carve-outs. Right, so there are some protections. Her memo addresses, right, if a person is actually an interest holder, a stakeholder in an organization, then that's an exception to this. I think your point is a good one too, Sandy. C-suite, right, because we talked about how generally supervisors are excluded from a lot of the NLRA protections. And I think our C-suite folks, right, the executive office folks, really high-level supervisors probably still can have these. She made a couple of other comments in the memo about what does or doesn't constitute a legitimate business interest that justifies the protections of a non-compete, and this causes yet another series of questions to arise about what will be enforceable. But so to your point, though, to the risk averse, I think limiting the use of actual non-competes to those really high-level folks is one thing. If you're going to have restrictions on lower level folks, use your confidentiality provisions, use your non-solicit, right? Don't take my customers, don't take my employees, but don't have a pure non-compete on those folks. And then you're outside the scope of this, you're outside the scope of those FTC rules, whatever they may look like when they come. And I think for most employers, those protections, right? Don't misuse my confidential information. Don't steal my employees or customers, which are generally way more enforceable and don't have a lot of these will they or won't they issues with respect to federal government intervention, potentially coming down the pike. Those really do provide most of the protections that employers want, but stop short of that non-compete. You just can't go across the street under any circumstances, which are problematic. And even without all this recent activity overlay, those have always been hard to enforce. Even here in Florida, there's a lot of issues, there's a lot of defenses, and a lot of other states we've seen, they've already outlawed them, right? California, you can't have them. Colorado, Massachusetts, Washington, they're starting to layer on a bunch of limitations. So I know we keep talking about non-competes, but it's an interesting area, and there's just been so much activity. We need to keep a close watch on it. But this NLRB memo yesterday really came out of left field, and has a lot of people kind of wondering what the world's going to look like in the near term on that front.
So Brad, if anybody wants to get in touch with you to discuss some of this, how should they do so? Sure,
I'm at Shoemaker in Tampa. My phone number 813-221-7425. You can find me on our website. I'm Brad deBeaubien at Shoemaker. So,
all right, and you all know me. You can contact me right here on LinkedIn, and I will put my contact information and I will connect you with Brad. So Brad,
you can also find me on LinkedIn as well.
Yep, we are here together, partners in bringing you the most updated HR news that you need to have.
Indeed.
All right, Brad, once again, it's always awesome to spend some time with you,